need to be complicated and detailed responses, and that additional days would be needed. And this case is pretty complex.
Yeah, those cases ordinarily haven't gone on for 40 years in order to try to obtain constitutional compliance. This is not really an ordinary business litigation matter. It does seem that there would be a reason to try to work together and have expedited proceedings so that we could arrive at constitutional compliance in a case that started in 1978.
Well, it actually started in 74. The order was in 78.
Okay.
I was in high school when it started, Your Honor, to give you some idea. But no, you're absolutely right. And that's what we're trying to endeavor to do. And that's why we should have, some additional time. Can we truncate the time? Maybe. But that's why another thing that didn't occur is both the appointment order and Rule 53 requires the court to give notice and opportunity to be heard if he's going to change the appointment order. And maybe we could have sat down and negotiated something to tighten up those days, but we wouldn't have ended up with 10 days. I mean, again, the University High plan is a good example because after we saw the R&R for the first time, TUSD scrambled around obtaining and submitting source materials, research, affidavits, summaries of interviews of experts, because we didn't have time for affidavits. They assembled over 400 pages of documents in support of it. And to do that with a 10-day deadline is problematic, which leads us also to the 7-day deadline. But that leads us to the 10-page limit. That's problematic because there's no restriction on how much the special master can file, and we have to deal with all of the USP requirements in the objection. And with regard to University High, there's like 10 or 12 of them, which is even harder task when the special master himself did not go through any of those. So we have to go with otherwise unrebutted statements like the one about cooperation and have to address that. But is there really any reason to go from 17 pages to 10? Especially in a situation where by doing away with all that briefing, they actually did away with a response, an objection, response, and reply, and to take all that briefing and reduce it to 10 pages, I mean, it really was just a bone to give us a small bit of due process. I'd like to save some of the remaining time, but the bottom line is TUSD is entitled to have an Article III judge that's engaged as the ultimate arbiter of USP compliance. It is extremely important. The case has been going on for so long, and TUSD, I can assure you, is working diligently and in good faith to achieve that status. And we're entitled to have some procedural and substantive safeguards per the negotiated agreements, Rule 53, a complete and accurate record so that if we're here 5 or 6 years from now, we're not going to hear somebody saying, well, it's not in the record. Otherwise, we fear unitary status will remain forever out of our grasp, and we absolutely don't want that. Thank you.
Thank you, Counsel.
Thank you. A couple of points I would like to respond to. One of them is the difference between the pre and post objection process in terms of the R&R. The pre-R&R briefing process involves policy suggestions, tweaking plans, and things of that nature. The post-R&R process is designed to be legal arguments and whether or not what is ultimately proposed complies with the USP and the Constitution. The special master under the system that is in place now is supposed to submit the information submitted by the parties with its R&R, but there is no legal briefing with that. Number two, it doesn't contain the information of communication between the parties because, and I'm quoting from an order, the court reaffirms its general preclusion of collaborative emails and red line draft versions. And it also provides...
I mean, it's hard to argue with that unless it's on a particular purpose. I mean, I think you probably can say, I don't think there's anything prohibiting you from making a legal argument and saying the R&R is factually wrong, and here's the declarations that show it, is there? You could do that.
Well, except that it also, it precludes us from filing things not covered by the R&R. And so if there are things that we didn't already submit because there's something new in the R&R, then we're handcuffed, and that's a big problem.
Well, no,
because,
I mean, just procedurally, then can't you just ask for leave to file it? And if it's it's not, if the court denies that, then that's an appealable issue at some point. I mean, it seems to me there are avenues for you to make the record. You may not like the results of the district court denying you, but
well, the problem is we've been turned away, and the problem is we need a record, and we need a real-time record. This notion that 5 years from now we'll submit all the stuff that we weren't allowed to submit and that's going to work is fanciful. But I'll give you another specific example. Well, there's a couple, but Judge Reinhardt referred to the Department of Justice pointing out that the special master had filed something, left out 400 or 500 pages of the record that the district had put in. I mean, that's going to be problematic down the road. Another one is, and this is really a good example of it, in the university high admissions policy, R&R, the special master makes a statement that basically all of the experts disagree with TUSD, or they're all in his favor. Not true, but we really can't address that because it wasn't brought up before then, so now we can't address something that we didn't address before. So it's this circle, and do we have to keep going back to the court, or should the court have not changed the plan everybody adopted and he signed off on before, get us together and get something that works, but don't put together this plan that doesn't. And the other issue I'd like to point out on the expert part, where basically in the university high situation, TUSD proposed using a test. The special master in his R&R does not say that the test proposed by TUSD is not compliant with the USP or the Constitution. He says, I like the idea of short essays. I think that would be the best practice.
In fairness, he said that was best practices, right?
Yeah, he said that's best practice. Best practice is not the standard for the Constitution or the USP. Now
you seem to be arguing a particular dispute as opposed to the procedure. That's what I was trying to get at earlier. Why is the procedure inadequate for you to lodge your objections to that ruling, if you will?
Well, because if we don't see it until we see the R&R, and we have a truncated time to respond, we have a truncated number of pages to respond, and we have restrictions on what that response can obtain, and the notion that we can solve all that by having to go and say, we want relief from the 7 days, we want relief from the 10 pages, we want relief from the restrictions on emails back and forth, we want relief from restrictions on things that weren't covered, that's unworkable, and we're entitled to have something that we can rely on because the record is so critical, and it's important going forward, because if he's able to do that on that issue, just saying, I'm going to decide that short essays are better than a test. I mean, that's clearly an educational policy, not constitutional thing. He can do it as, his fingers are in the budget, in boundary lines, in closures of schools, everything else. That is something that should be made by TUSD, and they get deference on, and not on the basis of a special master back east who's an expert on desegregation, but not an expert on running TUSD.
You know, what to me is bothersome about listening to this argument and this appeal is, as you said, this started before you were in high school. I would think you'd be wanting to work to a solution. The whole argument seems to be about building an appeal at the time you finally get through with this. Then you want the right record, then you want the right things, and then you're going to start litigating after it's all done. Isn't it something where you can hope that you're getting to something that you're going to support and accept and have a solution to this instead of a whole new lawsuit about why it's all wrong?
Absolutely. And here's why this appeal is important, because in order for people to negotiate things, there has to be some sense that that everyone knows what the rules are, and what, if the worst thing happens, we have to litigate, what's the outcome, what due process do you have, what resort to the court do you have, and unless you can go to the district court, get them involved, and get them to make the decision, it makes the negotiations tough.
You know,
And the parties have been working together.
You picked the special master. It was your recommendation, the school boards. It ought to be, when he gets through with these reports, that ought to be the end of the case. You ought to both be accepting, even the things you don't like.
Well, and the parties have been working together. The bigger problem is what the special master does unilaterally and without review, and that's what we're really complaining about.
Right, but you have the right to object, and I know you say it's burdensome, but let's take your specific objections. You say that they made the special master made a finding that's not supported by the record. Well, you can say that and just ask for leave to file some more documents. Now, I realize that's burdensome, but you know, we have briefing rules, and people ask us to file longer briefs from time to time. We grant some, we deny some. If you're concerned about making a record, you have to make a record. We can't solve this by micromanaging the procedure.
Well, I think that and that's a problem, frankly, in deciding whether to take this appeal, but two things were happening simultaneously, because TUSD's world blew up in December of last year when they had all these rules that were just, to my mind, unfathomable as someone who's been practicing law for 35 years. But the non-receptiveness of the district court to give us hearings, to allow us briefing, cuts us off at the knees on our rights to object that everyone had stipulated to, combined with the other expansive efforts by the special master to now he's really an advocate. He's become the education czar, not the desegregation expert, helping to consult with us together collectively to get unitary status, but someone who's an open advocate. He has a lawyer. He got a lawyer. I mean, things have been, it's really insane. And the problem is, and the reason why we took this appeal is because it affects not only the record, but the ongoing operations of the school district for the foreseeable future, and impacts 50,000 students. To kind of finish the loop about this starting with me in high school, my twin 13-year-old daughters just took the University High admissions test. So, I mean, these things are impacting people on a daily basis. That's why we want the procedure there so that we can get review.
How many real problems do you have? I think counsel said there were 3. University High, what are the other 2?
Well, I'm not in a position to answer that question because I'm not involved in the day-to-day, but the USP has a bunch of different plans covering everything.
And the parties stipulated to those.
And the parties stipulated to them, and a lot of those, the parties agreed to some of them, and some of them we have disputes, and some of them we haven't dealt with yet, and some of them change on an ongoing basis because, some involve with school closures, and we may not have that till next year.
But I'm just getting to the point where you said the special master has his fingers in all kinds of things. This was the plan the parties agreed to going in, right? And this is the special master that the district nominated.
I'm not sure. I wasn't involved in it, so I don't know who nominated him, but ultimately I think the parties...
the briefing tells us that. It's
with
not...
I think the Mendoza plaintiffs were the only objectors to his hiring. But what has happened is he's stepped beyond his bounds.
Well, that goes to the point that I made a minute ago, and I don't mean to prolong this and keep you at the podium, Pat. You probably want lunch, but at some point. But the game plan and the USP was worked out by the parties.
Right, and we have no objection to the USP. We have no objection to the appointment order, but we want those procedures followed, and that's what's not being followed. And what it has done is, what we've seen is the district court remove himself from this litigation and the special master move in and expand and use a standard that is not the standard that he's supposed to use. He's supposed to talk about compliance with the USP, desegregation, those sorts